Before trying to understand how to prove call recording or SMS or email or a CCTV footage in court, we must understand what is the meaning of a computer in the eye of the law. The definition in the eye of the law is generally different from the regular day-to-day usage definitions. In the eye of the law, mobile phone is a computer. CCTV footage recorder is a computer. Cellular service provider, whosoever is offering you cellular services, is a computer. The email service provider, Yahoo or Gmail or Google, they also shall be treated as computer. So the definition of a computer is very much exhaustive and inclusive in the eye of the law. Now, the second point to understand about how to prove the electronic evidence, and these all come under electronic evidence: mobile phone recording, landline phone recording, SMS, WhatsApp, all related transactions or transmissions pertaining to mobile phone come under electronic evidence. Email is an electronic evidence. Now, CCTV footage is an electronic evidence. So, electronic evidence is very broadly defined in the eye of the law. Now, it is a branch of documentary evidence. Now, there are only two kinds of evidence that are regularly sifted in the courts. That is oral evidence and documentary evidence. Oral evidence means a person comes into the witness box, suffers cross-examination, and then gives evidence. That evidence is called oral evidence. And the second form of evidence is called documentary evidence, where a document speaks for itself, the contents of the document, the person who signed the document, the witnesses on the document, the source of the document, everything must be proved. Now, electronic evidence is a branch of documentary evidence. It is not a branch of oral evidence, it is a branch of documentary evidence. We can call it sub-branch of documentary evidence. So, if these points are clear, so what is a computer, what is electronic evidence, and what is documentary evidence? Then I'll explain how to prove call recordings or SMSs or emails or CCTV footage. Let us limit this argument, this discussion, only to these four subjects. Though electronic evidence is very vast, for a better understanding of everybody, I am limiting my discussion only to these four subjects. Okay. Now kindly refer the recent Supreme Court decision, which is in the description box, which put rest to 20-year-old confusion pertaining to electronic evidence. How it must be brought to court, how it must be proved. All this is exhaustively settled. The law was settled by the Honorable Supreme Court in a decision which is in the description box. Kindly go through it, given 1 week ago. Now, how evidence is proved in court? Now, for oral evidence, a person will come into the witness box and speak, and he will suffer cross-examination. There is absolutely no doubt about it. For documentary evidence, you get two kinds of documents. There could be original and there could be a copy of the original. Always original cannot be brought to court. In such kind of circumstances, a copy of the document can also be brought to the court. For example, registration extract from the sub-registrar's office. A copy of the extract is sufficient to permit and prove your case. The court will allow a copy of the registration extract. Why? Because registration office cannot be brought to the court. So whatever is not brought to the court, whatever can't be brought to the court, a copy is permitted, provided it is certified. Now understand, certification is most important. Preferably, court always considers only original evidence, whether it is oral or whether it is documentary. But it also accepts a copy of the original evidence, which is called secondary evidence, subject to certain conditions. Subject to somebody certifying that it is a copy of the original, its authenticity is fine in accordance with law, and some other conditions. Now, in the eye of the law, if original could come, now in the four types of evidences which I am trying to explain, electronic evidences, mobile phone can come to court. So that is treated as an original evidence. So the holder of the mobile phone, if he enters the witness box, submits the mobile phone or a memory card to the court, then it is fine. In the same way, the SMS or WhatsApp messages, the owner of the mobile phone, if he submits the mobile phone to the court along with his entering into the witness box, suffering cross-examination is sufficient. This is what Supreme Court decided recently. Now the third is email. How will you prove an email? You can take a printout of the copy of the email. But the printout of the copy of the email is a copy. Where is the original? The original is in the Google server somewhere. The original is in the Yahoo server somewhere. That is, whosoever is providing the email service, they have the original. How will you prove the email in such kind of circumstances? The server manager, whosoever is holding the original of the email, must issue a certificate. Now Supreme Court clarified that if they refuse the certificate, if they refuse to issue the certificate, then Supreme Court clarified that court has absolute power to summon the in charge of the server. So hope you are getting the point. And the fourth is CCTV footage. A CCTV footage original shall be with the owner of the CCTV recorder. That CCTV recorder must be brought to court and the owner must enter the witness box and prove the case. If the CCTV footage belongs to the government, now traffic police CCTV footage is submitted to the court. Now somebody who is in charge of the server where this CCTV footage is stored or recorded or maintained must issue a certificate, and that certificate must be brought to the court and he must enter the witness box and prove the original of the CCTV footage. So in this way, the point you should understand is wherever the hard copy, wherever the hardware is, that person must enter the witness box. That hardware must be brought to the court. That hardware must be brought to the evidence. It must be submitted in the court as evidence. If that hardware cannot be brought to the court, then a certificate must be submitted to the court by the person who is in charge of the hardware. Now Yahoo servers and Google servers cannot be brought to the court. In such kind of circumstances, a certificate is necessary. If they fail to provide the certificate, that itself is sufficient to summon them. Then it is the responsibility of the court to see what should be done. Your point is to apply to the court to summon if he is refusing to issue a certificate. So this is how electronic evidence is proved pertaining to call recordings, SMS, email and CCTV footage. For CCTV footage, you can't make it into transcript. For call recording, you can make a transcript. It is better and convenient to the court to make it as a transcript. That is, whosoever spoke, you have to show both parties or three parties, and if you put it on a paper, it is very easy for the court to understand. In the same way, the printout of the SMSs can also be taken. To take the printout of the SMSs and to take the call record data, you can also seek the help of cellular mobile companies. If they fail to provide the data, then you can also summon them by filing an application in the court. So this is how you can record the electronic evidence and you can prove the electronic evidence in the courts. This is the brief procedure I am trying to explain. The rest of thing your advocate will explain you. Okay, thank you. Thanks for watching. If you have any doubts, kindly comment.